Paragraph 24, mediation. It's a long paragraph, describes a lot about mediation, gives you a lot of information that's not really contractual in nature, but it's more informative in nature. So you've got an explanation of mediation. Mediation is fundamentally where two parties come together, can't agree on something, put usually in two different rooms, sometimes together, both sides' stories, and one person goes back and forth and tries to get to a settlement. It's very effective most of the time because the third party is neutral and you get to hear the other side of the story. Okay, so often we all hear one side and we tell people our side, so everybody around us is saying, yeah, they're wrong, they're dumb, I can't believe that. But then you come into a room and someone who's a neutral says, but have you ever thought of this? Or do you really want to spend 3 times the amount of money we're talking about enforcing those rights? So parties have to agree on any settlement. The mediator cannot push a settlement on you. This provision says that disputes will be mediated. It's not jeopardizing your right to go to court later. Most courts require mediation these days. So if you file a lawsuit first, if I were representing one or the other party and say the buyer filed a lawsuit without attending mediation, I would just file a motion to stay or stop or hold or make sure that lawsuit doesn't go any further until there's a chance for mediation. Now you say, well, is the judge going to do that? In most cases, because there has to be mediation before we can go forward, and the judge is giving you a chance without court time and our resources, because remember our tax dollars pay for the courts, without much resources to settle the issue. In this paragraph, you get to choose who the mediator is. You get to choose where you want the mediation to be. You get to choose who's going to pay and how many fees there are. If you sign an agreement, it's your agreement, but once you've signed it, it is binding. But there's no breach or waiver of you to pursue any other remedies that you may want to pursue in this case. So you're not giving away any rights that you would have. And it doesn't apply to the filing in the courts that a lawsuit is pending. And that most common way that happens is what we call lis pendens. Very, very cheap. $10 to file, one-pager that lets everybody know that you can, and seller, this is not good for you, that you can buy this property if you want to, but there's a fight. Parties are fighting. And if the buyer wins that fight, then all you're buying is the right to use that property, I guess, until the court says otherwise, because the court could say it belongs to the buyer, and that was what prevails. So you don't have to mediate before you can file what we call lis pendens.